Are we really headed for blasphemy laws in the UK? And is discrimination against white applicants becoming the new norm? Well, I'll take a look at it in this video and whether it's lawful, because a lot of you have sent me comments and emails, and I'm quite alarmed by some of the things that I've seen and read. There is even an official parliamentary working group to define so-called anti-Muslim hate or Islamophobia. I'll take a look at that in this video as well, because I think there's potential for concern there, but I will cover that in a couple of different ways. But first of all, if you do enjoy or appreciate my content, please do subscribe to the channel. I am independent. I depend on you to do that. I have no big company behind me pushing or anything like that. It's just me. And I plan to spend a lot more time on YouTube moving forward, bringing these things to you. So I'd really appreciate it if you do subscribe and help me to remain independent and commit more time to YouTube. So thank you very much for that. Let's take a look at this, shall we? Let's take a look at this bit first. The first half of the video, I'll look at this anti-Muslim hate and Islamophobia definition working group. They're working to define Islamophobia. But let me start with a sweeping caveat. I have lots of friends and colleagues and people that I train with who are Muslim and from different faith, and I get on with them all. I like to think that I'm the kind of guy that gets on with everybody that I meet, and I have not a bad word to say about anybody that I've personally encountered. They work hard, they're very friendly. So none of my video here is intended to be or to be taken as being offensive or critical, etc. This is just a legal commentary on what's happening here, because I think this has the potential to backfire. Whilst it is obviously set up to be anti-hate, I think that it might ultimately curtail free speech and it might backfire. There might be a lot of people that retaliate against this if they do come up with some sort of definition, and it may be the source of trouble. And in my view, it's probably unnecessary anyway, but I'll explain why I say that. But let's take a look at it first of all. The Anti-Muslim Hate or Islamophobia Definition Working Group. Now, this is only from March this year. Statement here by Lord Khan of Burnley. And of course, this is spearheaded by Angela Rayner, who made the following statement set out here. She said, the government's established a working group to provide a definition of anti-Muslim hatred or Islamophobia, chaired by Dominic Grieve, King's Counsel. The group will advise the government on how best to understand, quantify and define prejudice, discrimination and hate crimes against Muslims. Details of the group's terms of reference and the membership will be placed in the libraries of both houses. They go on to say that incidents of anti-Muslim hate crime are at a record high and that the group's work will support wider efforts, etc. It does clarify that the group's proposed definition will be non-statutory. That means it's not strictly binding in every sense of the word. Anything statutory is the letter of the law, literally, and you can't deviate from that. But this is a non-statutory definition and will seek to provide the government and other relevant bodies with an understanding of acceptable treatment and prejudice against Muslim communities. So, emphasis on what is acceptable treatment and what is acceptable prejudice against Muslim communities, because there are some acceptable versions, which it goes on to say. The group's proposed definition must be compatible with the unchanging right of British citizens to express freedom of speech and expression, which, importantly, includes the right to criticise, express dislike of, or insult religions and/or the beliefs and practices of adherents. This work will support these important freedoms, ensuring that they are preserved. But that does raise the question as to why is this necessary in the first place? Because if the right to the freedom of expression is maintained, which includes the right to criticise, express dislike of, insult the religions or the beliefs or the practices, etc., then why the need for this working group to come up with a definition? There's another reason I think it's somewhat unnecessary, and that is because for something to be a hate crime, the clue is in the word. There needs to be a crime underlying that. And that is already dealt with quite comprehensively. The Sentencing Council guidelines, now I've made my criticisms in the past of various things, and these are free for you to criticise and give your views about. Let me know in the comments what you think about this, but a hate crime is quite clearly specified here. If we look at, for example, a racial or religious aggravation, now there are others based on disability or sexual orientation, etc. But let's focus on racial or religious aggravation for now. An offence is racially or religiously aggravated for the purposes of the Crime and Disorder Act 1998 if the offender in a crime that's already been established demonstrates hostility towards the victim based on the membership or presumed membership of a racial or religious group, or the offence is wholly or partly motivated by racial or religious hostility. And if so, then quite rightly, it attracts a higher maximum penalty than the non-aggravated version of the same offence. So for example, it could be an assault, it could be burglary, it could be criminal damage, it could be one of a number of different offences, and the offence underlying it remains the same with the same elements of the offence, etc. However, if it is then deemed that it is motivated by some sort of hostility towards the victim or a group, based on the membership or presumed membership of the racial or religious group, or it's motivated by any kind of hostility in that regard, it is then treated as a hate crime and attracts a higher penalty. But as I say, coming full circle, that then begs the question, why the need for a working group to define what they say is hate or Islamophobia if the hate crime definitions that bring it into line with a hate crime already exist? Now, that then obviously raises the natural question, does this mean that we might end up with some sort of blasphemy law in the UK? Well, if they strictly adhere to the laws of the freedom of expression, as they suggest that they will here, firstly, there should not be any kind of blasphemy law because it should not curtail free speech in that way. But then that begs the question, what's the point of this group and what's the point of the definition? Because if the definition does anything other than bring it within the specificity of a hate crime, then it is very plausible that it will create a new offence or a new wrong of some sort, be it that criminal or civil, of blasphemy. Because this statement expressly says it will look at what is unacceptable treatment and prejudice against Muslim communities. But what does it mean by unacceptable? Does that mean that it's a civil wrong? Does it mean that it's a new crime? Because if it's unacceptable, then if it were oppressive and unacceptable, then we get into the realms of harassment and that sort of thing, which is going beyond what is free speech and becomes harassment because it is either grossly offensive or oppressive and unacceptable, meaning it can cross that criminal threshold. But as I said, there's many different crimes that already fit that definition where your speech, such as inciting racial hatred or another crime that is motivated out of religious hatred of some sort, as we found out recently when people have gone to prison. They are motivated in that way and they already exist. So again, full circle. This is a circular argument. What is the point in having this definition if not to create a blasphemy law? Now, if they did create a blasphemy law, sort of creating this law by the back door by some kind of definition that is non-statutory, but the definition is there. Therefore, if you do or say anything which fits this definition, which is thus unacceptable treatment and prejudice, does that make it a crime? Or what does it make it? Because if it's not a civil wrong and it's not a crime, then there's no point in having it. Unless, of course, we're going down the route of the non-crime hate incident reports, which is, I suspect, where we are headed. Then we end up in the situation where you have a blasphemic non-crime hate incident report recorded against you, and that could have all sorts of untold consequences for your employment. For example, if you work in a school and this flags up on your record that you've got a blasphemic non-crime hate incident recorded against you, you may either lose your job or not be employed by that school if any of these come out. Now, speaking about employment, that will lead perfectly and neatly into what might well be discriminatory recruitment practices, which I've spoken about before, and it's even more blatantly obvious in some cases than others, but I'll come back to whether this is or is not blatantly discriminatory in just a moment. Don't go away. As an aside, you'd have heard me talk about digital IDs recently. Do I trust our government with digital ID? No, I don't. I don't even trust companies with my information. In fact, unless it's like a bank or an insurance company and, companies that you have to give your true information to, I don't even like giving my information to those companies because invariably it gets shared, it gets sold, and I get loads of junk marketing which tells me that it's on its way out there somewhere and could ultimately end up on the dark web, and somebody could try to steal my identity. So no, I don't trust them with that, and that is why I wholeheartedly recommend a company called Incogn on this channel, which is designed to contact data brokers and marketers and request and require, using UK law and US law, to remove your data from their servers. So they can't share it, they can't sell it, and hopefully it won't end up out there on the dark web for somebody to put together and try to impersonate you and then take out phones and contracts in your name. As a firm, we've had lots of clients over the years come to us who've been the victim of identity theft. They've had phone contracts, they've had loans taken out. One of them even had an issue with the property transfer because they had somebody trying to transfer the property because they had enough information about them. And that was a real difficulty getting that sorted out. But Incogn is a bespoke service that contacts all these companies that have gathered together your information. They put you together like a jigsaw puzzle, and they require them to remove your data from their servers. So they can no longer sell it, they can no longer share it, and hopefully that then doesn't happen to you. You get access to a dashboard. You can see the progress of just how many companies confirm they've got your data, which is staggering and scary at the same time. And obviously, because they're a partner to my channel here, I get you a fantastic discount, which is 60% off. That's 60% off an annual plan with Incogn, using the code BlackBelt with the link that's on screen and in the description below. And then you'll get access to the dashboard. It will show you just how many companies confirm they've got your data. And once you've done that, there's no going back. You see just how many companies say, yes, we've got the data and we may remove it. And some of them take longer than others, but you will see them gradually remove your data. So don't forget the code BlackBelt at the checkout, at the link in the description below. That will get you 60% off. It is an absolute bargain to help you save countless hours of contacting these companies to remove your data. So thank you to Incogn for sponsoring this video, but please don't delay. Use the code, use the link, and put Incogn to work in removing your data from those companies. So now, having dealt with what may or may not end up a blasphemy law by the back door and override or overlap with hate crimes in some way or another, now let's look at recruitment practices, because somebody else tipped me off to one of Rupert Lowe's posts here, who said more blatant anti-white racism on show in the Premier League, this time from Fulham FC. Banning white men from applying for coaching positions. Are white men also not welcome at Craven Cottage? Should they not pay for their season tickets? We must eradicate anti-white racism, says Rupert Lowe. And he quote posts here a screenshot of what I found, I think, to be this join the coach section on Fulham's website here, where it advertises a position of £30,000 per annum and details what the role of the coach is, career-changing coaching opportunity, etc. However, the bit highlighted, the bit complained of. This opportunity is a positive action, which I'll come back to in a minute, scheme open to male coaches from Black, Asian and mixed heritage backgrounds. Female coaches from all backgrounds. So you can see quite clearly females from all backgrounds, but male coaches only if you are from Black, Asian or mixed heritage backgrounds. Now, what does the law say about all this? Because some people, with respect, misunderstand and think that this is, in all its forms, unlawful. And that's not quite true. But I will come back to what I think about this in just a moment. Not legal advice, not statements of fact, just my opinions based on the reading of the law. You know the drill by now. I guess we have to have any kind of awkward defamation conversations, but there we go. So it's my opinion based on the facts and the law. Now, as I've talked about before, the Equality Act provides protected characteristics, and it would be unlawful to discriminate against somebody, i.e. treat them less favourably, directly or indirectly, because of one of these characteristics. Those are age, disability, gender reassignment, marriage and civil partnership, race, religion or belief, sex and sexual orientation. So if a firm didn't hire somebody because they were married, that would be unlawful discrimination. If they didn't hire somebody only because they were gay, that would be direct and unlawful discrimination. If they made the application process easier for people that were married, or easier to demonstrate that they were suitable for the role because they were married, that might be indirect discrimination. It may well be direct discrimination, depending on what they do. But each of these protected characteristics make it unlawful to treat somebody less favourably unless there's a good reason to do so. The good reason to do so is if there is a legitimate aim, and what they do is a proportionate means of achieving that legitimate aim. And in the Equality Act, with specific regard to employment, generally, and specifically regarding recruitment and promotion, but generally to begin with, it does permit positive action. Now, what does positive action mean? Well, that means taking a step to enable or encourage a group that shares a protected characteristic that might otherwise have a disadvantage that they want them to help them to overcome, or to meet some needs, or simply to enable them or encourage them to participate in the activity, etc. And with specific regard to recruitment and employment, we take person A and B, where they are treating person A more favorably than person B. There is a criteria that they have to meet. First of all, the person that they treat more favorably because of a protected characteristic, such as a background, etc., they have to be as qualified as the next person to be recruited or promoted into that position. The employer may not have a general policy of treating persons who share the protected characteristic more favorably in connection with the recruitment or promotion than persons who do not share it. So it cannot be a blanket policy of treating that group more positively, more favorably than anybody else. Thirdly, taking the action in question must be a proportionate means of achieving the legitimate aim that's referred to in subsection 2. And that is where it says that this act does not prohibit the employer from taking an action with the aim of enabling or encouraging persons who share the protected characteristic to overcome or minimize the disadvantage or participate in the activity. In English, that means that they can do a specific recruitment drive. They can turn up and hand out leaflets. They could do an event. They could do a seminar. They could do a webinar. They could do all kinds of different things to encourage groups of the community, whether that be for disability, whether that be for women, whether that be for an ethnic minority group. They can take each of these positive steps to assist and enable each of those groups to participate, to overcome disadvantages. For example, if they want to increase the proportionate representation of disabled workers within the company, they could travel to another location to enable them to apply for the jobs there rather than making them travel for interview and things like that. There's all sorts of positive action that they can take, because one person might say, why don't you travel to my city to do that? Well, there might be a good reason. They might be taking positive action to go elsewhere. But coming back to this here, this essentially says all females can apply, and males only if you're from Black, Asian, or mixed heritage backgrounds. In other words, no white male applicants. Now, that, for me, as a lawyer, rings alarm bells, because it reminds me of a case, a summary of which I will borrow from JMW Solicitors, which I will link below for credit. They summarise the case here. This was the case of Furlong and the Chief Cheshire Police. Mr. Furlong, a white, heterosexual, non-disabled male, applied for a position as a police constable in the Cheshire Constabulary. Although successfully completing the assessment centre and interview stages, Mr. Furlong was told that he was unsuccessful in his application. He believed this was because Cheshire Police had treated other candidates with protected characteristics more favourably during the interview process than him, and that those candidates were not as well qualified. Now remember, they had to be as well qualified as one of the requirement criteria. He believed that they were not as well qualified. Mr. Furlong then went on to submit a claim for direct sex discrimination on the grounds of sex orientation, race and sex. Cheshire Police defence was that they'd applied positive action in line with the Equality Act to increase the diversification of their workforce. They went on to disclose a vast number of statistics, one of which claimed that there were 127 candidates that were of equal merit at the time that he was interviewed, but the tribunal was required to analyse a plethora of evidence in the context of the requirements discussed here. Mr. Furlong's claim was successful. There was a clear finding of direct discrimination. He was successful because the police force had failed to satisfy the legal requirement when exercising positive action. Cheshire Police had applied a policy of positively discriminating during their recruitment process. This was also applied in large volume, which could not be considered reasonably necessary based on the evidence. They'd also not proven that they'd a reasonable belief that there was a particular barrier to candidates with the protected characteristic. Recent statistics suggested that by the interview stage there was 100% recruitment for BME candidates and 73% of LGBT and female candidates, and thus the tribunal said that their blanket approach of positive discrimination was not considered proportionate means of achieving the legitimate aim. They'd not considered the impact, and thus Mr. Furlong's claim for direct discrimination was successful. So am I saying that this post is automatically discriminatory on that basis? Well, not necessarily. They would have to robustly justify their position, which they may well struggle doing. In other words, if a white male applicant wanted this job, but was obviously restricted from doing so, they might then be minded to file a claim. The club would then have to defend its position and show that it was justified and proportionate, and that this positive step was justified in the recruitment process. Now, I strongly doubt that a club like this would put this post out without consulting its lawyers. I'd certainly hope not. But even if they have done that, they might still face a claim from somebody aggrieved, because this, to me, just my opinion, you understand, looks like a blanket policy of no white British males need apply. And if that is a blanket policy, that might not be justified depending on what they bring forth to a tribunal if there's a claim brought against them. So this really is, I think, where we are headed now. We've got, on the one hand, in the first half of the video, what very much looks like it could create some kind of blasphemy law by the back door, or at the very least, some kind of application of blasphemy that is applied to you in some scenario that is unacceptable. Whether that's a civil or a criminal thing, I'm not really quite sure. Because, as I said, I think it's unnecessary given that we already deal with it with hate crimes. And on the other hand, are we now to expect this kind of discrimination? Not making a statement of fact that this club's policy here is discriminatory, but are we generally expected to accept that discrimination is now the norm when they put these job posts out, in that you are just barred from applying? Because that is, on the face of it, directly flying in the face of the Equality Act, which prohibits unlawful discrimination based on the fact that you might be a white male candidate. So let me know what you think about that in the comments below. These are real things, and as I said, I will commit much more time to you here on YouTube covering these things. If you subscribe and if you like the video and you share the video and my channel keeps growing, I will spend more time dealing with things here. And I've got an anniversary for my channel coming up, and there's lots of exciting things to come. So stay tuned for those. Make sure you subscribe. Lots of great announcements coming up very, very soon. So thank you for watching, and I'll see you next time.